Today for legal method, we'll be talking about hierarchy of courts. Now, this video will be very short because I'm losing daylight. Yeah, this is around evening time, so I wouldn't want, and my light is not charged. So please bear with me if I will be very fast. Will be faster than you. Of course, you have the feature to pause and go back and all that. So just bear with me, yeah? The hierarchy of courts is not so technical. You will understand it as we go on. And why is it important as a year one law student? Why is it important for you to know the hierarchy of courts? Number one is that you will see it in exam, so you have to know it. Number two is as you progress in your studies, legal method is like the foundation that you have. As you progress, as you are building upon the foundation that you have laid in your legal method, you will be seeing a lot of times where people are talking about, okay, we are going to court, which court will you go to for law of contract, for example, in your 200 level. If you breach a contract, which court are you supposed to go to? So if you don't know this hierarchy of courts, you will be discombobulated on the particular court to go to when a particular problem arises. So you need to know your hierarchy of courts. And you also need to know the courts that have which jurisdiction. Now, that brings me to jurisdiction. Now, before we understand the hierarchy of courts and how courts are being stratified, we need to understand the meaning of jurisdiction. Now, what is jurisdiction? Jurisdiction is the power of a court to hear a matter. It's the power of a court to hear a matter. Now, there are types of jurisdiction. So you don't just say, oh, this court has the power, you go there. There are types of jurisdiction. We have the appellate jurisdiction, we have the original jurisdiction, we have the concurrent jurisdiction, we have the coordinate jurisdiction, we have the substantive jurisdiction, we have the procedural jurisdiction. So all these types, I've just listed them out for you to go and read it on your own. Yeah, when you finish reading on your own, you can now understand, because it's very easy to understand. But I think the one that is really not easy, people have been confused about, is concurrent and coordinate. Concurrent jurisdiction and coordinate jurisdiction. What are the differences? Now, coordinate jurisdiction is two courts that have equal powers. Now, when I mean equal powers, I'm meaning it in the sense that none of the two courts can appeal to each other. Yeah, because of course, when you talk about appellate jurisdiction, when you talk about a court that is higher than another court in level. So coordinate means we are classmates. It's just classmates. Do you understand? So if I'm in SS1 and you're SS1, we are coordinates. We are classmates. So if I'm a court and I'm in SS1, you're a court, you're in SS1. If I adjudicate on a matter, you cannot, if you don't like how I adjudicated on that matter, you cannot go to my classmate, because my classmate cannot overrule me. You can go to my senior, who can overrule me. That my senior has the appellate jurisdiction. Me and that my other classmate has coordinate jurisdiction, because we have equal powers. We are coordinate. Now, what is now concurrent jurisdiction? Now, it is possible that the two courts that have coordinate jurisdiction might not have jurisdiction on a particular thing. Yeah, so this court might have, okay, this is just what your powers are going to focus on. This is what your powers are going to focus on. But when it comes to power and who to appeal to who, two of you are equal. But the things that people are supposed to focus on are different. For example, in Federal High Court, we have the exclusive jurisdiction of the Federal High Court as enshrined in Section 251 of the Constitution. Now, why is it exclusive? It's exclusive because it is only the Federal High Court that have powers on those matters. It does not mean that the State High Court and the Federal High Court are not equal. They are equal because you cannot appeal from the State High Court to the Federal High Court. But the Constitution now listed out matters that the Federal High Court has only the jurisdiction to hear. Now, when we now talk about concurrent, remember I've not explained concurrent, I'm just laying a foundation. Concurrent is now, okay, this particular subject matter is what this person and this person can handle. So like we said, the Federal High Court have exclusive jurisdiction to handle some kind of matters, some matters, while the State High Court has jurisdiction to handle some matters. So any matters that this State High Court and the Federal High Court have the same jurisdiction to handle, that two of them can handle the matter. No one, that particular matter is not exclusive to any of them. They have concurrent jurisdiction on that particular matter. Example, fundamental rights action. Are you getting me? So coordinate jurisdiction, equal powers. We are not talking about what they have jurisdiction to hear. They have equal powers, as in their level of powers are the same. No one is higher than each, or than any. Concurrent jurisdiction. They have jurisdiction to hear one matter. This court can hear this matter, this court can also hear this matter. But coordinate is not that's one matter. Coordinate is just power. They have the same level of power. Do you even understand what I'm saying? Because it's sounding as if you are not understanding. Coordinate jurisdiction, they have equal power. Coordinate jurisdiction is like the jurisdiction, they are equal between two courts. We are talking about two courts now. Coordinate. Concurrent is that what this person can do, this particular matter now, this one can do it. Because ordinarily, every court that comes out have what they are good at. For example, we have section 254A of the Constitution that talked about National Industrial Court. And National Industrial Court has exclusive jurisdiction to hear matters pertaining to labor, employment, etc. So that is their exclusive jurisdiction. But if there is any matter that National Industrial Court can handle, that the Federal High Court can also handle, and the State High Court can also handle, on that particular matter, the National Industrial Court, Federal High Court, and the State High Court has concurrent jurisdiction. Do you understand? Yes. So, if you don't understand, just comment below. I will type for you. Now, I think that's the one that usually confuses students. Others you can read on your own. Now, for you to know the particular courts that have jurisdiction. Now, original jurisdiction, of course, is the power of the court to hear a matter for the first time. So the first time this matter is coming to court, where is it going to? Oh, you have committed assault. Where am I supposed to file my matter first? Do I go to the Supreme Court? Supreme Court is the highest court now. Why don't I just go there and not waste time in other small courts? Is it possible? Can I go to the Court of Appeal? Since the Court of Appeal is a very senior court that have 3 justices, why should I be wasting my time for one judge of the High Court? Is it possible? After we are done with this lesson, we will know whether it's possible or not. So, hierarchy of courts. First of all, you should understand that we have inferior courts and we have superior courts of record. Yeah? Now, the inferior courts, we have the customary courts, the magistrate courts. Now, the customary court, listen attentively. The customary court is called customary court, of course, in the south, and area courts in the north. Listen. Now, above the customary court is the magistrate court. Magistrate court in the south, district court in the north. It does not mean that magistrate court is not in the north. Listen, but anytime you hear magistrate court in the north, it is on criminal basis. It means that district court is sitting as a criminal court. So magistrate courts in the north, even though yes, it is still the same as district court, is district court, in the north. But when it wants to hear criminal matters, it is magistrate court. Do you understand what I'm saying? In the south, it is magistrate court normally. In the north, it is district court. However, in the north, it doesn't mean that magistrate court does not exist. In fact, it is magistrate court only when it is in a criminal matter. So, but if it is in a civil matter, it is called district court. Yes. So that is it. Now, we now go higher. Magistrate court, district court. Okay. Customary courts, area courts are in the lowest step. Magistrate court, district court. So when I say magistrate court for south, district court for north. Remember I also told you about how magistrate court sits in the north. When it is called magistrate court in the north, only on criminal basis, criminal matters basis. So above customary court and area court is magistrate court and what? District court in the north. But hold on a second. Where does an appeal from the customary court go to? Have you asked yourself? Anytime you go to a customary court and you are not happy with the decision, especially in the civil aspect, civil law. Remember your civil law and criminal law classifications of law. All these things are on top of each other. In civil law, in civil proceedings, the customary court, if they give a judgment and you don't like the judgment, you want to appeal, you appeal to where? You appeal to the customary court of appeal. Customary court of appeal. Customary court of appeal. Now, the customary court of appeal is for the south, from the customary court to customary court of appeal. However, for the north, it is the Sharia court of appeal. Now, above the magistrate court, listen to this thing I'm saying. Above the magistrate court is the high court. the High Court, when I say the High Court, if I just say only the High Court, just know I'm talking about State High Court. The State High Court, the Federal High Court, coordinate jurisdiction. Remember what I told you about coordinate jurisdiction, yeah? The Federal High Court, the State High Court, the Customary Court of Appeal that I just talked about, it is still the same jurisdiction in power or coordinate jurisdiction with the High Court. So it has the same power with the High Court. So we have the State High Court, the Federal High Court, the Customary Court of Appeal, the Sharia Court of Appeal. We now have the National Industrial Court, which I also talked about. It has the same power in level, coordinate jurisdiction. These are courts of coordinate jurisdiction. National Industrial Court. Then we have the Court Martial. These are the same, the coordinate jurisdiction. Now, the High Court and the Federal High Court. Before, when I was in year 1 in Faculty of Law, I was thinking that because State High Court, of course, states, federal, that you can appeal from states to Federal High Court. But I was corrected. That no, you cannot appeal from states to Federal High Court because the two of them, these two high courts, have coordinate jurisdiction. So these courts I just mentioned are above the magistrate and the district court, of course, magistrate and district court, south and north. So you can appeal from the magistrate court to the High Court. Good. Now, from the High Court, where do you go to? Or from the Customary Court of Appeal, or from the Federal High Court, or from the National Industrial Court. Remember I told you that all of them are equal. They are the same jurisdiction, coordinate jurisdiction. All those ones are above the Magistrate Court. High Court, Federal High Court, Customary Court of Appeal, Sharia Court of Appeal, National Industrial Court, Court Martial, etc. Now from there, above all these ones is the Court of Appeal. The Court of Appeal. The Court of Appeal, you can appeal from all these courts I just mentioned to the Court of Appeal. Now, above the Court of Appeal is the Supreme Court of Nigeria, which is the final say. If you don't like the decision of the Supreme Court, you go to God, because there is no other court that will talk after the Supreme Court has talked. Yeah? So that is how the hierarchy is. Now, remember I said we have original and appellate jurisdiction. Now, original jurisdiction is the power of the court to hear a matter for the first time. Most of the times, we see that in the customary courts, they have original jurisdiction as pertaining customs, lands in rural areas, customs. Magistrate Court has jurisdiction to hear criminal matters, especially those ones that the punishments are not above 14 years. In the civil matters, they have jurisdiction to hear civil matters, landlord and tenant relationship. They have civil jurisdiction to hear matters that the monetary amount is not above 10 million. So 10 million and below. Magistrate Court. So these are original. They have the matters to hear. But High Court also have original jurisdiction to hear both criminal and civil matters, especially matters relating to land. Generally, in customary law, they might be talking about land boundaries of land in rural areas that concerns, when you use land and you pledge, and your forefathers were the ones that pledged the land, and you have to use custom. This is omenala in Igbo land, or the custom in. So that is where you talk about it. But when you want to talk about land, as in you are dragging land with somebody, it is High Court. You cannot even go to the Magistrate Court for land matters. Original jurisdiction, High Court, criminal matters. Any civil matter that maybe is above 10 million. Now, the Federal High Court has its jurisdiction embedded in Section 251 of the Constitution. You can check it. So things like copyright infringement, drugs, etc. Original jurisdiction. Matters that they can hear for the first time. Court of Appeal, even though it has appellate jurisdiction from these ones, has matters that it can hear for the first time. For example, when the presidential election is completed and somebody is saying that he won the election, the other one is saying he did not win the election, there is a contest on who won the election. The Court of Appeal is the people that you can go to, and they will tell you who won the election. Just like Peter Obi and Tinubu, they started from the Court of Appeal. The Court of Appeal is like the Presidential Electoral Tribunal. Original jurisdiction. You cannot start presidential election matters in High Court. No. You go to the Court of Appeal, you start it for the first time there. When you want to talk about is the seat of the president vacant, what amounts to the vacancy of the seat of the president? How many months is the president supposed to be outside the country and you now say, the president, the seat is vacant? It is the Court of Appeal that can answer those questions. So when you have these kinds of matters, you go to the Court of Appeal. Original jurisdiction. Not only the president, whether also the seat of the vice president is vacant. Now, Supreme Court being the highest court of the land, they also have matters they have original jurisdiction over. Which means those matters, you don't need to go start from High Court or Court of Appeal anywhere. You go straight to the Supreme Court. These are matters that has to do with disputes between states and states. Matters between the federation and states. Now, I did not say federal government and states. I say federation and the state. Now, you might ask, what's the difference between federation and federal government? Federation is when it concerns Nigeria in totality and as in a whole. That is, you're talking about the federal, state, and local government. I'll give an example. Just recently, there is something about local government autonomy and local government allocation that they went to court, and the court says that, of course, local government should be granted autonomy and the state government should not be interfering with the financial allocation that is coming in from the federal government to the local government. Now, that is a federation suing the state governors for always chopping the allocation of the local government. Now, it is not the federal government, but the federation. And why is it federation? Because it concerns Nigeria in totality. That is the local government. Because the local government couldn't have sued. Of course, they are the slaves of the of the governors. So it took the federation, the Attorney General of the federation, to sue the states. So when the matter is between federation and the states, it goes to the Supreme Court first. Now, apart from that, when a matter is between the National Assembly and the states' houses of assembly, it goes to the Supreme Court. When it is also a matter between the National Assembly and the President, it goes to the Supreme Court. So, I mean original jurisdiction. These are the matters that Supreme Court has original jurisdiction. That means they have the powers to hear it for the first time. Now, your exam might come in a way that might want to confuse you. They will not tell you that, somebody has started a matter in the Customary Court and he has appealed to the High Court, or he has appealed, and it's a civil matter, he has appealed to the Magistrate Court. Advise the parties. Or he has even appealed to the Court of Appeal. They will not tell you advise the parties. Now, you tell them that from the Customary Court, you only appeal, especially if it is a civil matter. You don't go to any other court aside the Customary Court of Appeal. It is only the Customary Court of Appeal that can hear appeals, especially on civil matters. From the Customary Court, the Customary Court of Appeal. Customary Court of Appeal from the Customary Court. Customary Court of Appeal from the Customary Court. So they cannot say, Magistrate Court, they have finished the matter in Magistrate Court, and they have gone to the Court of Appeal. You say, no, you cannot catch me. From the Magistrate Court, you go to the High Court. From the High Court, you now go to the Court of Appeal. Don't confuse me. They not tell you, they have finished a matter from the High Court, and he has appealed to the Supreme Court. You say, it's a lie. I know what you want to do. It is a lie. It's from the High Court, you go to the Court of Appeal. From the Court of Appeal, you go to the Supreme Court. So you must know your hierarchy of courts, because they might come in exam and they will want to confuse you in order to test your knowledge of your hierarchy of courts. And you must, after you must have finished watching this video, and you go and fail a question that comes from hierarchy of courts, you know that your village people are too strong. All right, so if there is any question you have, now I told you that I was losing daylight. You can see here it's a little bit kind of getting dark, that I will be fast. If you have any questions and you did not understand some of the things that I was saying, please do it to comment your questions. I will be there to answer. Thank you very much. God bless you.